Hello, and welcome to another episode of eDiscovery Chicks, the podcast about all things eDiscovery and legal tech, hosted by two gals who are still recovering from all the fun we had together last weekend. Anyways,
Woohoo!
we're your hosts. That's Bree.
And that's Angie. And in today's episode, we're doing a little bit of show and tell, should we say? I'll show you mine and you can show me yours. We're going to spill some tea.
Ooh, spicy.
But before we really go down that road, we did have some visitors drop in to see us.
I know, and I am so excited. So, listeners, we are joined very briefly today by two women who have pioneered a set of really amazing conferences that span the US. We are talking to Allison and Jennifer, and they have pioneered the Techno Security conferences. So, we want to spotlight the Techno Security East conference that they are putting on from June 2nd to 4th at the Sheraton Myrtle Beach Convention Center in Myrtle Beach, South Carolina. But before I get ahead of myself talking about this amazing conference, Jennifer and Allison, welcome to the pod. Can you introduce yourselves to our listeners?
And thank you, Bree and Angie, for having us today. I'm Jennifer, Salvadori, now Crumblish. Nothing has changed here as far as our staff, but our locations and a lot of other things have changed. I'm the event director, and I have been here working on the Techno Security and Digital Forensics Conference now since 2015. It's been over a decade.
Wow, you've been in this space for a while. Allison, I want to welcome you too. Can you introduce yourselves to our listeners?
Sure. I'm Allison Dowd. I'm the Senior Manager of Content and Marketing for the Techno Security and Digital Forensics Conference. And I have been with the conference for 9 years, coming up in April.
Okay, so can you tell our listeners a little bit about the Techno Security East Conference that's happening on June 2nd to 4th of this year?
I'll just give you the overall. For those of you who are not familiar, it's our 27th year for the flagship event on the East Coast. We blend together the private enterprise sector with the public and government sector. eDiscovery professionals, lawyers, forensic, digital investigators. Allison will go into a little bit more detail about who we attract with the conference program that we do put on. This year is super exciting. It's the long-awaited, much-anticipated return to our flagship location, Myrtle Beach, South Carolina. We were there for over 20 years. We're in Wilmington the last 3 years. We outgrew the space at the Marriott Myrtle Beach. And so it was a logical move at the time, but I think there's a lot of nostalgia and folks, really all the stakeholders, exhibitors, speakers, attendees, vast majority wanted to return to Myrtle Beach. So we're excited that that is happening this year. June 2nd through the 4th, our traditional time frame for that conference on the East Coast. With it comes some changes as well as far as returning to our roots in digital forensics and blending in that eDiscovery portion, which is why we're here with you today. For Allison, she can go into a little more detail about what you'll find at the conference from an educational standpoint. I handle more of the sponsors and the logistics of the event. And this year, with that return to DFIR, we have a new set of primary conference tracks. Allison, you want to tell us a little bit about that change for this year?
Thanks, Jen. Like Jen said, we're returning to our roots in digital forensics. And really what that means, when Jen and I were talking about this, we had this visual in our head of a circle, like a graphic of like digital forensics in the circle, and then these satellites, I guess, going around it where digital forensics was in the core. And that's kind of how we came up with the new tracks. So we have a digital forensics track, an incident response track, an ICAC and human exploitation track, cyber and financial crime track, and then, of course, our eDiscovery track.
Yeah, I love the diversity of y'all's conference. It's something that I look forward to going to. I go to both of them, West and East, every year. So I'm excited. For those of us who have not been to the Myrtle Beach location, what does that atmosphere look like? Like, if I'm coming, who's going to be there? What am I wearing? What is the vibe like? I mean, these are the things that are important to me, people. Come on.
Bree wants to know what to pack in her suitcase when
Yes,
she comes.
I do.
Well, it will be a little bit different this time. The core audience is still going to be the same, and it's growing, obviously, especially with AI and the emerging tech and DFIR coming on board with with the vengeance. It's just all over the place. So we had to really create a new track there to keep on top of the industry. But the vibe itself whereas the Myrtle Beach Marriott, our home location for all those years, was right on beachfront, or probably about 5, 6 blocks away from the beach. So you won't be able to walk out. That's probably good. We'll keep people in sessions. But it is close to the Broadway at the beach where all the fun stuff happens, Senior Frogs. And actually, that area, when we went and did our site visit, has expanded tremendously. It's got a whole new section with some cool venues, bars, restaurants. And the location itself is more of a true convention center conference. Small like Wilmington, but has the size rooms where we can do so many of our breakout sessions and product demos going on at the same time. It's a business environment, but it's a very emphasis on the business casual because
Yeah, we
of the
always say
location.
business casual, right, Jen, with the emphasis on casual.
Yes.
We're at the beach.
Yeah.
We're at Myrtle Beach, so it's like
I mean, it's
whatever
something
you wear, Britain, will be great. Yeah.
it's always a very comfortable environment at your conferences, which is one reason I enjoy going because I find like when you can be comfortable with the people that are there in the community, you learn a lot more. You're able to network a lot more. I've met more people at Techno Security over the years than I've met at any other conference that I've been a part of. So for me personally, it's been a great networking tool. It also teaches me so many things that are outside of my normal day to day so that I have a broader perspective of the eDiscovery, industry that I tend to be in every day, which overlaps some into forensics as well. But it helps me to have a greater perspective, I guess, for legal tech. And I always learn something every single time that changes my life, that you just didn't know was a thing until you went to this conference and you're like, holy crap, that's going on in the world. Like, wow, I had no idea that existed. I had no idea what we are doing about it. I had no idea how I could be involved. I highly, obviously, recommend coming to this conference. And I appreciate the fact that you guys have such a diverse track offering that you have put together. Is there anything else about Techno Security East that you want to share with us before Angie and I get on to our regular scheduled program?
I would just encourage those of you who are joining us. Each year we get about, let's see, 52, 53% are first time attendees on the attendee base. So it really is a cool, diverse group. You get a blend of the old and the new, the people just starting the industry for those who have, 20 plus years of experience. But if you are going to join us, I would definitely recommend securing your hotel room sooner than later. One of the benefits this year that we did not have in Wilmington that I failed to mention was we are under one roof in one headquarter hotel. We did miss that a great deal, and it did impact our decision to return to Myrtle. Instead of being in three different hotels, you can come back to the bar and find your people. And I agree with what you said. It's a relaxed environment where that networking is just so easy. It just flows. I always say, if you come up with something in your day-to-day workflow that you haven't experienced before, you can reach out to someone that you met at Techno. If they don't have the answer, they'll refer you to 5 or 10 more people they met at Techno. And it really is a cool community. So I would encourage everyone to join us this year with the big return to Myrtle.
Great. Well, thank you so much for joining us. Bree and I are now going to get back to our usually scheduled antics.
Thanks
Thank
so
you.
much for having us, you guys. Looking forward to seeing you in Myrtle Beach.
Bye, guys.
Thanks, Jennifer and Allison.
All right. So I did promise that we were going to spill a little tea today. So, Angie, before we do that, you mentioned when we did the intro that we spent some time with each other this last weekend. Well, I had so much fun. It was so great to see your town. I got to go to Seattle for the first time ever.
Oh my God. It was so great. We loved having you. I have to say, Bree's like the best house guest ever. You're one of those people where it's just like there's never enough time. I think we could
Aw.
talk for 12 hours straight. Like if you put us on a cross country road trip, I don't think there'd be a moment of silence.
Well, it would be double the time because I'd probably drive by the exit about 10 times at some point. But
I'll drive. We'll get there fast.
yeah, you should probably drive.
Oh
um,
my God. Well, how was your Mother's Day?
so,
Uh-oh.
knew you were going to
Mixed
ask me
bag?
about this, and I was trying to get myself prepared to be positive. We'll just
I don't think you
say
have to be. Mother's Day is like a mixed bag.
Mother's Day is not my holiday. It is my stepmom, my real mom, and my mother-in-law's holiday. And so that's kind of where the focus goes, which is great because I love those ladies and I'm glad that they're still in my life and I will definitely miss the day. Well, I mean, who knows who's gonna go first? It might be me, but, like, if there's ever a day that they're not around,
Are
I will definitely miss that.
you a
Um,
diplomat? Because this is
I
a very diplomatic answer.
no, because I'm about to tell you the part that was really annoying, which
Okay.
is, apparently the boys in my house, they freeze in, like, the headlights, like deer in the headlights when it comes to holidays and don't know what to do. It's like, "Aw, I know this comes around once a year, but what is this about again? Like, what wait, we're supposed to spoil mom. Wait, what is that? Oh, they're supposed to be presents or something?" And yeah, there was
What?
not a whole lot. And not anything that happened was like for everybody else, which
Oh,
if you're a mother, you know the feeling of like, why do I do everything for everybody else and nobody's got my back? So that was kind of my Mother's Day, unfortunately, but I have a feeling I'm probably in the majority of mothers. So
yeah.
if
I
we were all
feel,
being honest.
yeah,
But yeah. How about I
for
hopefully
sure.
you're I mean, I did have a nice time. We took my mother-in-law on Mother's Day to a really great fish fried shrimp dinner, and then we went to go see the Michael Jackson movie, which is, freaking amazing, and can I just tell you, I love my part of town that I live in because it's extremely diverse, and so when we go into the movie to watch Michael Jackson, there's, like, every kind of person in that theater. And people are just, like, sassing back to the movie. Like, Michael Jackson's dad got a, no, you didn't." Like,
Oh, I
people were
love it.
people were talking back to the dad. People, like everybody, including myself, was, like, singing along with all of the songs and, like, dancing in our seats and stuff. Like, it was so fun. My son said it was his top 5 favorite movies of all time, which I thought was so
Whoa.
cool. I was
Oh
like,
my God, that's amazing.
yeah, you got, like, somebody in their 80s, you got some people in their 50s, and then you got a teenager, and we're all like, "That was a bomb movie." But, it's part 1, so it's, like, all the fun
Oh, I
stuff.
did not know that.
Yeah, and
Oh, and then we're gonna get into the gross stuff?
yeah, I don't really know if I wanna go back for part 2 because I know how that movie
Yeah,
turns out.
it's sort of like the second VHS of the Titanic box set where you're like, "Do I?"
Yeah. How was your Mother's Day, by the way?
So I also have very complicated feelings about Mother's Day, like most Hallmark holidays, I'm sort of like, "Eh." But then I just had my Mother's Day experiences when I was growing up were extremely stressful. I just never really wanna celebrate it. Like,
Yeah.
the only thing I wanna do on Mother's Day is, like, I wanna go on a run, and I want nobody to ask me a question. I'm like, that's all I want, that and I am perfectly happy. But this year, so we had some friends spend the night. Br Bree, different Bree, not you, B-R-I Bree, you are B-R-E-E Bree,
The young
but
fabulous Bree.
the fabulous Bree. But so Bree and I bought these creepy, like, Halloween masks, ghoul masks. Banshee masks, I think, actually, is what they are.
Mhm.
And so we put these creepy masks on and are sitting in bed together watching Pacific Rim at full volume at 9 o'clock in the morning when they come in. And, and so we terrify them. We'd had the kids stay upstairs because we were worried these masks could be so scary that they would, like, traumatize the children. We take them, like, eventually the kids come into the bedroom, they see the masks, and Harper's like, "I love it." So she's been wearing this ghoul mask around the house, but she takes it off in random places, so that sometimes I'll just, like, find this ghoul mask, like,
That
in
is
somewhere
so
really
funny.
random. Like, it was in my bathtub this morning, I don't know why, and
Like, what were you
so
doing?
so now it's really backfiring, right? Because I keep going, "Ugh," like, I see this creepy thing.
Well, we promised today that we were gonna spill a little bit of tea. So,
Yes.
and by the way, listeners, you need to understand that Angie, being counselor that she is so excited about this episode because she loves her some case law. And I had to think about it for about 5 months. I think I don't know how long I've had it, but I'm like, "Angie, nobody wants to hear about case law, like, it's the most boring thing ever." But then I was like, "Well, there might be people out there that, number 1, like case law, but it actually kinda does matter." So, I should probably not blow it off because it's kinda important. I will tell you that we are going to summarize. It is going to be from our perspective. Please, if you want to know all the ins and outs of these cases, go research them yourself. But we want, we do,
Add our commentary.
we are. So, this is not your typical boring case law spiel. And that brings us to the first case that I want to talk about that's all about girls being baddies and changing the way the world looks at
Ooh,
us and
love
looks at law. But before I get going on this first case, Angie, why are you so excited about case law? Why does it even matter?
Okay, there are a couple ways to make law in this country. You can pass legislation, you can issue an executive order, regulatory agencies can issue directives. But one of the most common ways is through case law, which is where you go, you litigate something in the courts, and the court makes a ruling. There are a couple different kinds of case law that exist. There's like state specific case law, and then there's federal case law. Case specific case law, i.e., like case law that comes out of state courts as opposed to federal courts, will only be governing in that jurisdiction. Federal case law, not the same thing. So federal district courts, this is, this is actually a hot topic, like up for debate and like depends on the subject matter. But some federal district courts, i.e. like the one that sits in your city or whatever, can make case law that affects the entirety of the US. This happened out of the Western District of Washington during like when Trump issued his Muslim ban. Western District of Washington said, nope. A friend of mine was actually clerked, the judge who read that case, which was really fun. But that happened. Then, most recently, there have been some case law rulings out of federal district courts related to mifepristone, which allegedly have impacted the whole country. Anyways, all of that to say, this is one way that you make law, and it's a big one. Interesting things about case law, though, is they are typically very like fact specific. So what the courts will do is they will apply the law to the facts of your specific case. So rulings are often tethered to the facts of whatever like was before the court. So there's a principle that the Supreme Court used to adhere to pretty stringently. That's changed over the last 10 years or so. But they used to rule as narrowly as possible because the idea is that you don't want to make these broad sweeping changes as a judiciary. You want to make incremental changes. That's changed. There's so much background to all of this that I'm really only skimming the surface about what case law is. So if you want to learn anything, like if you want to learn more about this concept of judicial restraint, the idea that the ruling should be narrowed to the facts, you can go and research everything having to do with Marbury v. Madison, which is one of the absolute seminal cases about what case law is in the US. And that's my spiel.
So I kind of see case law like the judge is a parent and you have like your kid has come home and you're like, hey kid, I told you that you're generally supposed to be respectful to your elders in this house. And then your kid's like, oh yeah, well what if I do this? And they're like, well, okay, so now you found a caveat to that rule that we were supposed to follow. And now I got to make up something on the fly to tell you what's going to happen to you if you're going to be a jackass. So, yeah, this is part of being respectful. And so
I love that analogy.
So we're going to talk about Zubulake versus UBS Warburg. The reason why we're talking about this one is that it literally was the first case that really set forward some precedents that we still have today that actually changed the federal rules of civil procedure and the sense of how eDiscovery is looked at from legal hold and preservation and from producing data and what your responsibilities are there. So it changed it forever. This is what happened. 2001, Laura Zubulake got fired from her job, which was working for UBS Warburg, which is a Swiss investment bank. We're going to think back to 2001. If anybody was working in those years, you can probably imagine what it's like to be at some highfalutin place run by a lot of guys. And you seem to be the woman that is the only girl in the room. So there were things that happened while she was there. She started getting some suspicions that because she was the only chick, that she was being treated differently. So Laura realizes, hey, they're discriminating against me. I'm going to file a complaint. And when she did, it is like the shiitakes hit the fan. So Laura Zubulake was a senior salesperson at UBS's equities division. And among the discrimination that she felt like that she was experiencing, she said that she was passed over for promotions. She had been excluded from client events, and the workplace environment in general was just not supportive of her as a woman. She files an EEOC complaint in August of 2001, then sues in federal court in February 2002. So that's kind of the time frame that we're looking at. And when she files a lawsuit, her lawyers went to UBS and they're like, hey, so we think that you're not being legit to our girl Laura here. We think that she's been discriminated against and she's has all these accusations. We need to see all the emails where all of this has been discussed. So UBS produces about 350 pages of documents, including 100 pages of emails. Well, that's cool, except for Laura had 450 pages of emails that she had saved on her own. Side note, cover your ass, ladies. Just
Oh.
saying. But based on the numbers alone, she knew that they were hiding something. Like, how in the world do I have 450 emails that are relevant and you guys are only giving me 100? That's weird. Then they demand the rest. And they're like, oh, well, and I've heard this one a lot, especially back in those days. We don't have them anymore. They're on backup tapes, and it is so very expensive and hard
Yeah,
for
it's like
us.
so hard for us. It's harder than it was for you to be discriminated against.
Yeah, and they're like, you know what? If you really want them that bad, maybe you should pay for them.
Yeah.
But know
Yeah,
that
you person who we just fired who doesn't have income. Please
right,
go pay for that.
that we discriminate against. Yeah, sure, go ahead.
Seems
So
legit.
enter the judge, Shira Scheindlin. Scheindlin.
Yes. The judge.
So also a woman judge. That's right. This is what happens when women get together. Things get done and things make history. That's all I'm saying.
And things get done right.
Most of the time.
Yeah.
So the judge was not going to play any games with these people. She ended up issuing a series of opinions, actually, that all had to do with the field of electronic discovery and preservation. These opinions were made before the federal rules of civil procedure even dealt with eDiscovery or anything about electronic evidence in the first place. So she was essentially writing the rule book in real time. The decisions became known as Zubulake 1 through 5. And so let's break down a couple of those. I'm not going to go into all of them. Like I said, I'm going to summarize this so you're not going to fall asleep. So UBS tried to make Laura pay to restore the backup tapes. The court was like, hell to the no, y'all. Judge Scheinlin proposed a 7-factor cost shifting test and ultimately ordered UBS to pay 75% of the restoration costs, with only 25% of that shifted to Laura. So Zubulake rule 1 and 3 kind of cover this subject matter. And it was the first time that anybody had ever really talked about who is liable for costs. And so this was a great precedence to set. Zubulake 4, the lawyers start digging into those restored backup tapes, and ruh-roh, some of those tapes are missing. Dun, dun, dun.
Dun, dun, dun.
And some of the emails that were supposed to be preserved were deleted. After UBS had literally told its own employees to keep everything, several backup tapes from the targeted time period were just simply gone. Zubulake 4 deals with the duty to preserve. And the time that you start doing that is the moment that you see litigation coming. Is it the moment that litigation is filed? No. Is it
Nope.
the moment that litigation is served upon you? No.
No.
It's when you see it coming, bruh.
No, there are cases where, like, if you're at, like, somebody from the upper echelons is at a dinner party and they hear something about another company trying to sue you, that in and of itself is enough to issue a legal hold.
I'm not going into any more dinner parties. That's it.
I'm not
like, I have to
socializing
issue
anymore.
5 legal holds after I've been in a dinner party.
No. What are you doing to people? Are you harassing them?
I'm like, well, I heard this might happen, and I heard that might happen.
Ooh.
Zubulake 5, during the follow-up depositions, Zubulake's lawyers found out about even more deleted emails. More missing documents and more, oops, we forget. So Judge Scheindlin, which can I just say I love her last name,
Oh,
wasn't
I love
well,
her.
besides Scheindlin, it's just Scheindlin and Zubulake. I feel like those are two names that are just amazing. But anyways, Judge Scheindlin was no longer in the mood. This time she granted the adverse inference instruction. The adverse inference instruction basically has to deal with if you do not produce it, we're going to assume that it's negative towards you. We're going to assume that whatever you left out is incriminating. So that is what adverse inference means.
It's a shade throwing jury instruction.
Look at you. I love that. Because UBS couldn't properly produce documents, their lawyers couldn't prepare their witnesses. And during the depositions, Laura's team caught them in massive inconsistencies. The head of HR, Michael Davies, had claimed that an email exchange calling for Laura to be exited by the end of the month had taken place before anyone knew about her discrimination complaint. But once the restored email surfaced, the timestamps told a different story. The
They
cover up,
always do, those narcs.
those timestamps, dude. So the cover up didn't just fail UBS, but it actually became the evidence. In 2005, the jury came back with a verdict, $29.2 million, and that is not Bree math. I hope that you're keeping up with me and all my stupid little antics. What we're really trying to tell you is that Laura Zubulake, who was like, bro, you can't treat me different because I'm a chick, and I have evidence that you did me wrong. She sued him. She complained to the EEOC, and she said, I want to see all the emails. And she covered her butt. She had her emails. She saved them. And they tried to cover it up. They tried to cover it up by not producing them the first time. Then they got called out and they were like, oh, it's so hard. We can't do the backup tapes. And the judge was like, get the backup tapes right now. And they were like, oh, but you got to pay for it. And they're like, no, how about you pay for 3/4 of it?
That judge was like, yeah, you think that's hard? Try childbirth.
Right. And then, and then
Nah, dog.
and then they're like, "Oh, except we couldn't find them all." And the judge was like, "Oh, so since you can't find them all, we're just gonna assume that all of those are incriminated and that you actually did exactly what she said. So joke's on
Uh-huh.
you, bros." So that's what happened. Before this case ever came to be, we did not have the idea of when we should consider the trigger being pulled. That was a vague area. Now we all know that the trigger is being pulled at the thought or the moment that it looks like someone might sue us or complain against us or have litigation against us or that there's an issue. At that moment is when the trigger should be pulled. So that was something that was definitely a takeaway.
Reasonable anticipation of litigation,
Thank
folks.
you. That's what I was looking
Drill
for.
that into your brain.
That's
Yeah,
why you get paid the big bucks. And so the other thing that was not super clear was whether or not it was cumbersome to pull things like backup tapes. And if it was, who was liable to have to pay for that? So that was ironed out here. And then if we forgot to produce something or we claimed something was lost, then how that might be considered in a court of law, which the cover up is always worse than the crime. Because if you'll notice, UBS didn't just lose because what they did to Laura Zubulake. They
Uh-huh.
actually lost more or worse, they lost harder
They
because
lost
of what
bigger.
they did to her evidence, right? So somewhere out there, Judge Shira Scheindlin is living her
God, what
best
a
life,
name.
knowing that she single-handedly dragged the legal profession into the digital age, 5 opinions at a time.
I also just I need her to be on Broadway with that name. You know?
Either that or to at least do the nightly weather. I'm Shira Scheindlin, Eyewitness News or something.
For KWTV.
Right.
Back to you, Rob.
But I will
Um,
just go ahead.
no, go ahead.
I will just say Judge Shira Scheindlin and Laura Zublake, hats off to you girls because you went above and beyond your Call of Duty. You went against the norm. You went against the dudes that were discriminating against you. You pushed them to it, challenged them. You weren't afraid to call them out. And it impacted history forever. And I'm super grateful for that. I love to see women making a difference in history that makes me proud. That is the older case that I have brought forward to you this afternoon to share where some of the roots of our eDiscovery guidelines have come from. I know that you have
Snaps,
something
queen.
new and scandalous to discuss, so
I
pray tell.
do. I do have something new and scandalous to discuss. But before that, snaps. That was amazing. Everybody does need to know about this series of cases. I'm so glad you brought that to our recording studio today. I'm going to cover Morgan v. V2X Inc. Okay, so by the time I'm done walking you through this case, you're going to know the 3 questions to ask before you put a single confidential document into any AI tool, and you will never look at your ChatGPT tab the same way. So, Bree, I want to start this off by asking you a question. So, it's 2026. You've just been fired from your job and you think it's sus. Like, you think there's some there, and you think you might want to take some legal action, but you kind of just want to understand your options at this point. What do you do?
While I am sitting at my local hole-in-the-wall Mexican food restaurant, eating chips and queso and drinking a top shelf margarita.
Naturally, yes. Cadillac, probably.
I
Scratch.
and, I would be sitting there tapped into probably Claude, ChatGPT, asking a few questions. What do I do next?
Yeah. So that makes a ton of sense. And that is exactly what Archie Morgan did when he was fired from his job at a defense contractor called V2X, which is a company that provides logistics, maintenance, and operations support to the U.S. military. So Archie, in the actual case documents and in the court opinion, he is quoted as describing himself as a, quote, qualified Black American manager. He says he was fired because of his race and national origin and because he blew the whistle on some sexual harassment happening at the company. Lot of ick there.
Mm,
So V2X says he was fired for legitimate reasons following a workplace investigation that involved more than 30 witnesses. So we talking about some drama here.
big time.
All right. Archie can't afford a lawyer. So he does what any resourceful person would probably do in 2026, and he opens up an AI tool and begins to build his case. Meanwhile, V2X has a full legal team and almost certainly enterprise-grade AI running quietly in the background. Now, here's where it gets interesting. V2X owes Archie an insurance policy disclosure. This is like standard stuff in civil litigation, but it is 4 months overdue, meaning that V2X has been hanging on to this insurance policy for fuck knows what reason for 4 months. V2X's lawyers decide to use it as a bargaining chip. They tell Archie, look, tell us which AI tool you're using, agree to restrict how you use it, and then we'll give you the document we already owe you. And Archie calls it exactly what it is, holding a routine discovery obligation hostage. So this fight lands in front of a federal magistrate judge in Colorado named Maritza Dominguez Braswell. And here's the thing about Judge Braswell. She is not a judge who just got an AI question sort of like dropped in her lap and then did her best. She actually co-founded something called the Judicial AI Consortium, and she co-chairs the District of Colorado's AI Committee. She is also an active member of the Sedona Conference working groups on eDiscovery and data privacy. This is like a very big national eDiscovery group, very well respected. But on top of all of that, she writes a newsletter called The AI Brief about AI's implications for courts. So the TLDR here is that she is a judge who has been living these questions. And what she wrote on March 30th, 2026, is the third federal ruling ever on AI and the work product doctrine. All 3 of those decisions, mind you, happened within a 7-week window. So like things are happening hot and fast right now as far as like judicial AI decisions go. But I think like in my IMHO, this is probably the most consequential AI and litigation decision we've seen yet. Because like not it's a routine employment discrimination case between a man with no lawyer and a defense contractor, but it has become the case that is beginning to set the rules for how AI and confidential discovery materials interact with each other in federal court. So, big deal, y'all. But I mean, the upshot of this is that, every single one of those federal rules has direct implications for every person who's ever opened a ChatGPT or a Claude or a Gemini window and pasted a document in or put any kind of confidential information into those engines. Here's what I want you to know by the time I'm done telling you this case. There are 3 things that any AI tool must contractually guarantee before you should even consider putting confidential anything in it. And here's the other thing. Most of the tools you're using right now, they probably do not guarantee those things. So let's dive in. I want to set the stage because, like I mentioned, there were 3 AI-related decisions that happened within the span of 7 weeks. So I want to set us up for success by giving you a little bit of history about those so that you understand why V2X is so consequential. First case was Hefner out of Southern District of New York, came out February 17th of this year. Criminal defendant, $150 million security fraud case. The defendant used Claude on his own without his lawyers knowing, but after he already knew he was a federal target. The court said no privilege, no work product. Critically, though, he also, he had lawyers too. He used Claude not at his lawyer's direction, but just sort of his own volition. Next case, Gilbarco/Warner, Eastern District of Michigan, Feb 10, 2026.
And I have a question.
Yes. Okay, and fire away.
So what is this all about? Does this mean that I shouldn't, if I'm in a lawsuit or something, I should not be using Claude or ChatGPT or any kind of AI engine to ask questions, help me draft, blah, blah, blah? Is that what you're about to tell us?
I love this question. And no, that's not exactly what I'm about to tell you.
Oh.
There are so many nuances to this, and it is such a burgeoning issue. Right now, not legal advice, disclaimer. I wouldn't put anything in any of these public-facing LLMs. Enterprise systems, different ballgame. You're a pro se litigant, different ballgame. We're going to dive in all that here in a sec.
Yay. Okay.
Yay. Okay, so Gilbarco/Warner, Eastern District of Michigan, Feb 10 of this year. February 10th, 2026. This is a pro se civil plaintiff, so already different than Hefner, who was a criminal defendant who was represented by counsel. This is a pro se civil plaintiff who used AI during discovery. All right, so the defendant tried to compel her AI materials, and the court said no. AI tools are tools, not people, and so disclosure to a tool is not necessarily disclosure to an adversary. All right, now third case. So that's Hefner, that's Gilbarco. So far, we've got criminal defendant represented by counsel, pro se civil plaintiff, i.e. unrepresented civil plaintiff. Third case is this one, Morgan v. V2X. And this is where those two lines meet, and the analysis in this case goes so much deeper than either prior case. So let's get into what actually happened. V2X conditioned that 4 months overdue insurance policy on Morgan agreeing to AI disclosure and certain protective order amendments. I want to pause. We're going to get a little bit into the procedural posture of this case because it's actually important. It's really dry. Stick with me. I'll try to make it fun.
Okay.
Cool. So protective order is just a procedural mechanism by which parties can be like, hey, listen, we don't want to disclose this or that, or we want to make sure that you're only using this evidence in this way. So that's what's at issue here. Morgan's like, look, this is not on the up and up. I'm going to file a motion to compel, which is Morgan basically asking the court to say, hey, V2X, you have to produce this thing that you owe me. Court schedules a hearing. And a hearing is where the court just allows both sides to come in and argue their position. And then the court will sometimes make a ruling from the bench, meaning in the moment. And sometimes the court will later issue a written ruling. So that's what's happening here, is they're supposed to have that argument session. But the morning that that's supposed to happen, V2X emails the court, and says the insurance issue is resolved and asks to vacate the hearing. You need to ask the court to say, all right, we don't need this hearing. The court did vacate the hearing, but then pressed forward with the AI motion anyways. The AI motion being V2X asking the court to compel Morgan to say what AI he was using. Basically, the insurance policy was leveraged to exact certain concessions, but once Morgan made noise about it, V2X kind of paid up and then pivoted and was like, all right, but you still need to do something for us. Now, an important structural flag for you. This opinion contains no citation to any rule or standard authorizing V2X to reopen that protective order that was already in place. And Morgan never challenged that. So a sharper litigant or someone who was represented by counsel, their attorney probably would have told them to argue that point because that would mean that the whole motion practice, the whole hearing couldn't happen. So what happened before this, the parties, V2X and Morgan, agreed to this protective order. Now Morgan's trying to go in and change that. Typically, if you were represented by counsel, your counsel would advise you to be like, no, we're not arguing this. We're not relitigating this. We've already agreed to it. It's a thing. It's happening. Whatever. Done. That didn't happen here. I wonder if it's because Morgan was represented, by himself, and he's not a lawyer. So just wanted to flag that up top. So the court tackles a couple of issues. The first one being work product and pro se AI use. So that's different than Hefner, where he's represented by counsel. This is pro se AI use. 26B3 is the federal rule in question, and the rule protects materials prepared, quote, by or for another party. So not just by counsel. Judge Braswell highlights the importance of protecting pro se AI use. Your pro se's work product is magnified in the context of AI because AI is one of the most powerful knowledge tools ever to become available to the masses. And a pro se litigant has to be both party and advocate simultaneously, meaning they must be the person actually litigating the dispute, mired in their emotions, in the facts, in their fields. And they also have to be their own lawyer. And that's really hard. And it can be an enormous disadvantage if you're going up against a corporate litigant. So one thing that Judge Braswell notes, that I kind of agree with, honestly, is that AI might be the first tool in history that makes that dual role manageable. Not ideal, but at least more manageable than it was before AI. So then the next question the court addresses is whether using an AI platform waives work product privileges. The work product doctrine protects materials prepared basically like in anticipation of litigation or like related to litigation, not just by attorneys, but it could be, materials prepared at an attorney's behest, or if you're a pro se litigant, something that you prepare in the course of mounting your defense or your prosecution of your claims. V2X's argument is basically Morgan disclosed litigation prep stuff to a third party, this AI tool, and that waives confidentiality. But the Judge Braswell says, look, nearly all electronic interaction passes through some third-party system. So does that mean anybody with a Gmail account has forfeited all rights to confidentiality and privacy? Anybody with a Microsoft account? Same deal. And she looks to two cases, Carpenter v. United States and U.S. v. Warshock, both of which say that routing data through a third party does not automatically extinguish privacy expectations. Now, there's an interesting social science point to be made here, too, which is that AI platforms are designed to make you share more. They simulate empathy and they foster trust and they interact with ways that feel intimate. Hell, I asked AI if my mom's a narcissist the other day, and I had a really deep conversation about it. And I'm reading this case law and I'm still like, hey, here's my soul. Like, let's talk about it. But anyways, Judge Braswell notes that the privacy interests in AI interactions may actually be higher than in traditional digital communication because of this interesting social component. Where she lands is this. Disclosure, in order to waive these protections, the work product protections, disclosure must be made, quote, to an adversary or in a way likely to get into an adversary's hands. And she concludes, naturally, that AI is not an adversary. Sometimes I feel that way when Claude gets sassy with me, but she's like, look, it's not an adversary. This is akin to all this other stuff, all these other third-party tools that we route our data through that don't amount to disclosure. Next thing, because V2X not only wanted to know what Morgan had talked with AI about, but it also wanted to know what tool Morgan had used. So that's a different question the court tackles. Does Morgan have to disclose which tool he used? Claude, Gemini, ChatGPT, etc. Morgan argues that his tool selection actually reveals strategy and an analytical approach. And there's some case law to back this up, right? There's some case law that says, your choice of platform or tool is reflective of your case strategy. But here, Morgan lost, and the reasoning matters. He made only conclusory assertions, which is a great way to shoot yourself in the foot when you're litigating. And what I mean by that is, I can say, look, these tools reflect my strategy and analytical approach. That's conclusory because I'm not telling you why or how. But if I were to say they reflect my strategy because I evaluated several different tools, one of which is uniquely positioned to provide me the kind of advice that I need for this case because the claims are A, B, and C. That's not conclusory. That's putting meat on the bones, right? And he lost on that issue. So let's talk about the next issue, which is what a protective order should actually say about AI. In this case, both parties' language was rejected by the court. So V2X proposed, an over-engineered, platform-specific, drafted around V2X's own existing enterprise contracts, not the needs of this specific litigation or the reality that Morgan lives in as a pro se litigant. Here's a fun little tidbit. So V2X's proposed language still referenced Google's Bard, B-A-R-D, which was their AI tool that was rebranded as Gemini over a year before this order was issued.
I don't even remember Bard.
It was like a thing for a second, right?
Wow.
So anyways, talk about like copy paste problems, right? So anyways, the Judge Braswell noticed. And I think, and yeah, I come from like a corporate defense background right here, but I think that kind of drafting, the carelessness of that tells you something about whose interest the proposal was actually designed to serve in this case. And that's just like, that's my commentary on this. But anyways, Morgan proposed language that the court also rejected as being too narrow. So his language focused on cybersecurity risks from bad actors, which is sort of interesting, but kind of completely missed what consumer platforms actually do with your data in the normal course, which is they store it, they train on it, and they share it with subprocessors. So the court's language, and I'm going to read this slowly because this is sort of the standard now of what you should be including in your protective orders, is no party may input confidential information into any AI platform unless the provider is contractually prohibited from 1, training on your inputs, and 2, disclosing inputs to third parties beyond what's essential to service delivery, with any third party bound by the same protections. And then the court goes on to say that any AI provider must also contractually allow deletion of all confidential information on request. And Judge Braswell says you should retain written documentation of those contractual protections. So you might be wondering, all right, what about the Claude I use every day or the ChatGPT I use every day? Well, Judge Braswell actually talks about that. And she says, she kind of acknowledges that this standard that she's laid out will, at least for now, bar most mainstream low to no cost AI tools from use with confidential materials. So kind of in practice, this is going to bar your free and low-cost ChatGPT, your Claude, your Gemini. Those are all almost certainly out for anything that's confidential. Even the enterprise tiers, like the $25 to $30 a month, like user minimums, those are still probably like not okay. What we're looking for is an enterprise infrastructure with those protections. It's not going to train on your inputs and it's not going to disclose them to third parties. She does also note, though, like without any additional commentary, really, that large firms are pouring thousands of dollars into enterprise-grade AI, and pro se litigants or litigants who can't afford big-ticket legal services might really struggle to keep up, and that's sort of a social justice or access to justice concern. She raises this, doesn't really like address it in too much detail in the rest of the opinion. Here are the 3 problems that, for me, when I read this opinion, it doesn't quite solve. So, number 1, there's a vector embedding problem because when you put data into an AI platform, it's processed into vector embeddings, which are sort of segments that are stored in a database. And then the data doesn't persist as a document, like it's not in its original form, it's been transformed. This whole right to delete thing that exists in the court's ruling for this case, it sort of assumes something that isn't really grounded in reality, which is it assumes that there's a clean extraction and removal mechanism with most of these AI tools. And that's just not quite how they work in practice. The enterprise grade ones might be different, but for your kind of run-of-the-mill stuff, there's just a database with segments of your data kind of living in it. And that doesn't make for a very clean, hey, can you go delete my data request, right? It's not like they're just keeping documents in there. Then there's also this sort of over-designation incentive problem that this ruling raises for me, which is that every document you designate as confidential is now a document your opponent can't run through consumer AI. So in my experience, like when I'm litigating, parties tend to kind of over-designate confidential documents. I mean, this isn't the same thing as privileged, right? Confidential can be business records or things containing sensitive business information. It can be stuff reflecting your CEO's opinion. You know, the bar is much lower. And so parties often designate things as confidential in litigation when they might not necessarily be, but kind of out of an abundance of caution. So here I wonder whether parties are going to start using this designation as more of a weapon than it already is, right? Anyways, that's the second problem. The third one I notice is there's sort of a scope problem. As an eDiscovery practitioner, I find this one kind of unsettling. There are so many tools that we use that use AI. it's like they're no longer a separate category of thing that we're dealing with, right? They're embedded into so many of our workflows. It's in our infrastructure, it's everywhere. And so if this is the standard that's going to extend to all litigation technology with AI baked in, I don't know how you comply with that as a practical matter,
Hmm.
right? I mean, some of these are enterprise systems and like that will help, but there's every system upgrade, every software upgrade,
Hmm.
that's going to change the calculus of these tools. So I just don't know as a practical matter how we're really going to comply with this order. If you're listening to this and you're like, all right, well, I kind of want to use AI. What do I need to ask to make sure it's safe? Here's what I would ask if I'm considering putting anything into my AI provider. There are 3 questions. Number 1, is your provider contractually prohibited from training on your inputs? Number 2, are they contractually prohibited from disclosing inputs to third parties beyond service delivery? And number 3, will your provider contractually allow you to delete all confidential information on request? If the answer to any of those is no or I don't know, I would say steer very clear of putting anything into that AI tool. And I think one thing to note about this decision too, like at the top, I flagged all of Judge Braswell's experience with AI. Her writing suggests that she uses AI all the time. But what this opinion does is it draws the line between tools that earn their trust and ones that don't. And so if you are a pro se litigant, if you are somebody like your corporate counsel, I would just say ask yourself those 3 questions. Is your AI training on your inputs? Are they disclosing them? And will they allow you to delete your information? Ask that before you do anything else, because that's going to dictate whether your AI is. That's not a carte blanche to go use AI. I'm just saying, like, that's the baseline, right?
I'm a little freaked out about using AI now, so thank you.
I will say I have continued to use it. I am just very mindful of what I put in it.
Yeah,
And if I'm using it to like assess a case or something, I'm making sure I'm pulling those case documents from the public record, putting them in, and then asking, questions of that because I'm not a practicing lawyer anymore. So it's different too. If I was a practicing lawyer,
yeah,
like, hell no, I'm not doing that. But
right,
for me, I'm just like, what's this case about? Can you summarize this?
right. So, Angie, we've talked about 2 cases that are wildly different. I feel a little bit like I cheated because my case is like super simple and easy and cut and dry, and it seems like it makes logical sense. Your case enters into a whole new world of considerations that I don't even know if I'm mentally ready to like unpack. Because some of it I feel like is, a little bit of a like you're intruding in my personal life. But I mean, I feel like there's so many nuances to the case that you shared that's so complicated compared to where we started. And so I'm kind of curious to see like where we go next. And I think it also talks to how complex our industry has grown over the last 20 plus years to know this is where we started and this is where we are and to understand where we're going and whoever knows what that is. What do you think?
Yeah. And we're living on a fault line right now between 2 tectonic plates, I feel like. And so I'm so curious what happens. I bet that we will see a deluge of decisions about what types of things you're supposed to include in your ESI protocol as far as AI goes. What types of things to include in protective orders, like what breaks privilege, what breaks confidentiality. I bet we're going to see a whole bunch of that. And based on what we've seen so far, I wonder if it's just going to be a real patchwork, jurisdiction by jurisdiction. Eventually, I imagine some of the higher courts will take this up, but I don't see that happening in the near term. So I think we're going
Mhm.
to be stuck in a weird little patchwork for a minute.
Mhm. Yeah, I'm sure. Well, it will be interesting to see where we go from here. So there you
Yes.
have it. Bree and Angie have spilled some courtroom tea. I mean, I think mine was a little bit more of a vanilla variety. Angie's was more of a matcha latte or something. I
So
don't know.
just, you heard banana matcha is a thing? And I'm like, ugh,
Ooh, that sounds
no.
delicious.
Oh, so we had
You're
polar
like,
opposite
"Girl."
reactions to that trend.
I'm like, let's go.
I'm like, no.
I love matcha everything. I also love banana everything. So
Anyways, that's all the time we have today, folks. Thank you so much for joining us on eDiscovery Chicks. We hope you learned something new, felt empowered, or just had some fun, and maybe now feel a little bit fearful of AI. but maybe excited too. Who knows? I'm not going to yuck your yum. All right. Join the flock by following us on LinkedIn and Instagram, and check out our website, eDiscoveryChicks.com. If you love this episode, please share with your network, leave us a review, or tag us on your socials. And don't forget to subscribe wherever you get your podcasts so you never miss an episode. Bye.
Bye. The views we've expressed today are the eDiscovery Chicks views and don't necessarily represent the views of our employers, partners, or clients. The podcast is available solely for educational purposes to provide general information about eDiscovery principles and not to provide legal advice to any specific situation. It is not a substitute for legal advice from a lawyer you retained or who has agreed to represent you.